Right. When we talk about the prescribed contents of the plan, I'm not going to go into too much detail because the Act contains a lot of details and requirements, and not all of them are necessarily even applicable in every case. So it doesn't really mean all that much. The main requirement is that the plan must contain everything that is necessary for affected persons to decide, for those who have a vote, whether they should accept or reject the plan. That's really all that the Act should have said, instead of listing all those requirements, of which many are not even applicable. And as the court said in the Commissioner of South African Revenue Services versus Beginsel, substantial compliance here is sufficient as long as you have the information that the affected persons will need to decide whether they want to vote for or against this plan. And apart from that, there's no sanction for non-compliance. So even if your plan does not contain all the prescribed information, there's nothing in the Act that states what will happen and what sanction is. There's no sanction. And there's no remedy for affected persons, as the court said in Absa versus Golden Dividend. It doesn't make sense to say the plan must contain all this information, but then if it doesn't, your affected persons have no remedy to do something about this plan, except, of course, that they shouldn't vote in favor of the plan. And some of them, unfortunately, do. Some creditors, maybe because they are not really aware of their rights in this respect, but you would be surprised at the very bad plans that some creditors, for some reason, are prepared to accept, and some of them then complain to the CIPC afterwards to say that they were intimidated into accepting this plan, and they voted for the plan although they were not really in favor of the plan. Now, if you do that, then I'm afraid you only have yourself to blame. Right, so there's no remedy and there's no sanction. So basically, it doesn't mean all that much to have all these prescribed contents. Right, then within 25 days after the appointment of the business rescue practitioner, this plan should actually be published. But as I said at the beginning, this does not really happen all that quickly. You can be given an extension by the court or the majority in value of creditors, and that happens in most cases. There was a judgment, I think it could have been DH Brothers, where the court said this extension must be given at a meeting of creditors, but that's not correct because that's not what the Act states. It doesn't require a meeting. The question, however, is whether only independent creditors should vote in favor of an extension of the period within the plan, within which the plan must be published. That is not clear. In any event, it must be published to affected persons in the prescribed manner. But again, there is no sanction if it is not published within the prescribed time and no extension was given or even requested. Now, in DH Brothers, the court said, well, in that case, that results in termination of the business rescue if you don't publish your plan within the prescribed period. But in ShopRite Checkers, as you will see in, I think it's discussed in your yes, I think it's in the textbook. Once again, the court in ShopRite Checker said, no, there's nothing in the Act that says that the business rescue will terminate. Your best bet would be to apply to court for the business rescue proceedings to be terminated because there's no prospect of a rescue, because without a plan there can't be a rescue. So that is basically all you can do. Right, then once the plan has been published, a meeting must be called to consider the business rescue plan. And this meeting must be convened within 10 business days after publication of the plan. Now, although long ago the court made it clear, I think it was also in the Beginsel case, that not all concurrent creditors are subordinated. In our law, a creditor is only subordinated if there is an agreement, a contract between the creditor and the debtor in which the creditor agrees to be subordinated. Otherwise, the creditor is not, a concurrent creditor is not subordinated. Furthermore, the business rescue practitioner cannot wait until the meeting takes place and then say to certain creditors, oh, actually, you are subordinated, so you only have a vote based on your liquidation value of the claim and not on the full value. The business rescue practitioner must, in fact, give notice at least 15 business days before the meeting to all creditors that he or she regards as subordinated, to tell them, I regard you as a subordinated concurrent creditor, and that will give this person enough time, this creditor, to apply to court to review the decision by the business rescue practitioner to classify him or her as subordinated. So if you don't agree, then you can go to court for a review. And the fact that you must have at least 15 business days notice is to give you enough time to apply to court to review your classification as subordinated if you don't agree with it. Okay, a notice of the meeting must be given at least 5 business days before the meeting to all affected persons, not only those who have the right to vote, but shareholders, for instance, who mostly do not have the right to vote. They must also be given notice of the meeting. I'm not sure why, because I don't think they have the right to attend if they don't have a vote, but still they have to be informed of the meeting or notified. Then the Act states that the representatives of the employees must be given an opportunity to address the meeting. So the employees can actually influence the vote by saying, we think this is a good idea, this will save our jobs, please vote in favor. Or if they don't like the plan, they can also do that. In most cases, it would probably be that they try to convince creditors as far as possible to vote in favor of the plan. But it is a right, and the business rescue practitioner cannot refuse to allow them to address the meeting. Now, when the voting takes place, even before voting, a new development of a new plan may be proposed by a creditor, and if the majority of creditors decide in favor of that proposal, then it's back to the drawing board for the business rescue practitioner. However, if the plan is supported by more than 75% in value of all the creditors who voted, and at least 50% in value of the independent creditors who voted, and no rights of any shareholders are altered, the plan is regarded as finally approved. Then, in other words, only the creditors vote on the plan. If the shareholders' rights are altered, the plan must also be approved by a majority of the relevant shareholders at a meeting that must be held immediately. Now, remember, as I said some time ago, remember that secured creditors have a vote for the full value of their claim and not only for the unsecured part of the claim. The effects of approval of the plan are quite important. First of all, the plan is binding on the company and each creditor. Now, although it says each creditor, I don't think the plan is binding on post-commencement creditors because they are not mentioned in the plan. When you look at the prescribed contents, it only talks about including all claims that existed at the commencement of business rescue. So I don't think you can bind post-commencement creditors. Surely they will, their obligations and rights will be based on a contract. Then the plan may not be amended after approval by the practitioners, even if the practitioners have reserved the right for themselves and it has been approved by the creditors that they can amend the plan if circumstances change. That is not acceptable. A plan can only be amended if a meeting of creditors is called again and they vote on the plan again, on the amended plan. So you cannot set it aside. That was held by the Supreme Court of Appeal in Kransfontein, where the court said you cannot. Once the plan has been approved, it is binding. You cannot amend it, and there is no way you can get around it. Furthermore, if the plan is approved, it is binding on everyone, on all affected persons and all creditors, even creditors who didn't know that the company was in business rescue, who didn't know about the meeting, who didn't attend the meeting, and who didn't vote on the plan, or who vote is anybody who voted against the plan. They are all bound by the plan. And you'll see there's a discussion of the Erevan case, I think, in your study guide as well, where the court confirmed that. Then you will see that Section 154 specifically provides, Section 154, let me see, it's 2, I think it is, where the Act states that, yes, 154.2, a business rescue plan, if a business rescue plan has been approved and implemented in accordance with this chapter, a creditor is not entitled to enforce any debt owed by the company immediately before the beginning of business rescue, which is why I'm saying that the plan is not binding on post-commencement creditors, but pre-commencement creditors are bound and they can only claim from the company in terms of the plan and not otherwise. The Section 154.1 states that certain debts can be discharged by creditors who exceeded. Unfortunately, we don't really know what they mean by exceeded. There must be some sort of acceptance by the creditors or agreement that a part of their debts may be discharged. Presumably only if the no, it says the whole or part of a debt. So nobody really knows what they meant by that. It's not at all clear, because if the plan only provides for payment of part of each creditor's claim and it's approved, is that then exceeded? That's not clear, because it can be done and it is done in most cases. So that section is a bit of a mystery to everybody. Now, in paragraph 1274, the last paragraph on page 320, and then also the first two lines on page 321, is a discussion on the effect of this plan, on an approved plan, rescue plan, on sureties. And I think there's also an extensive discussion of that in your study guide. However, after all these years of uncertainty, where some judgments said the sureties are not bound by the plan, others said sureties lose their claims if a plan is approved, or they can only claim in terms of this plan, we now have a Supreme Court of Appeal judgment that was issued late in 2021. Van Sale versus Auto Commodities, you will see the reference there. Now, the problem was always that, first of all, the Act doesn't say anything about the situation of sureties, whether they are affected by the plan or not. Secondly, the second problem was that in terms of our common law, if you are a surety and for a certain debt, and that debt is discharged or disappears, then you are no longer liable as a surety because you cannot be a surety for a debt that does not exist. So, because Section 154.2 states that the creditor cannot claim or enforce a claim, a pre-commencement claim, except to the extent that the rescue plan provides for it. The feeling was, well, then this debt has now been settled. So the surety is no longer liable for this debt or the balance of the debt. The Supreme Court of Appeal has now come out very clearly to say sureties, the liability of a surety is not affected by the approval of a rescue plan. So it doesn't matter what the rescue plan does with a certain debt, the surety is still liable to the main creditor for the debt or the balance of the claim insofar as the company doesn't pay it. So the uncertainty has now been removed. Sureties will remain liable for the debt or balance of the debt, even if a business rescue plan has been approved. And among other things, the Supreme Court of Appeal said that it is the debt has not disappeared. The debt still exists, even though the rescue plan has been approved. The only effect of the rescue plan is that the creditor cannot enforce the debt except in terms of the plan, but the debt still exists. So that problem of that we had with the common law that said you cannot be a surety for a debt that doesn't exist, this debt still exists. It's just that it's not enforceable. So the sureties will still be liable to the main creditor. Right, so that's at least one problem that has now been solved. Okay, if the rescue plan is approved, the business rescue practitioner must oversee implementation of the plan. The business rescue practitioner has the authority to issue shares if the plan requires that, if these shares have been authorized. In other words, they're in the memorandum of incorporation. If the shares have not been authorized, they're unauthorized shares, then the shareholders also have to approve this plan, and only then will the business rescue practitioner be allowed to issue these unauthorized shares. And then, of course, to amend the memorandum of incorporation to provide for those shares. And then once the plan has been substantially implemented, the business rescue practitioner must file a notice of substantial implementation in the prescribed form to show that the business rescue has now come to an end. And it's important to file this notice, because if the business rescue practitioner does not file the notice, then he or she is still on record with the CIPC as being the business rescue practitioner of this company and still liable for any breach of fiduciary duties. So the BRP must file this notice of substantial implementation to terminate the business rescue procedure, so that the practitioner is released from his or her duties. Okay, that is if the plan is approved. However, what happens if it is rejected? In other words, you are unable to get the necessary percentage of votes. Now, there are three solutions to this. The first one is that the practitioner or the creditors may propose that a revised plan should be drafted. And if this is approved by the creditors, the practitioner must prepare and publish this plan within 10 business days. However, the practitioner can also decide that he or she wants to apply to court to have the votes against approval of the plan. So in other words, the votes that rejected this plan for these votes to be set aside as inappropriate. You must do so within 5 business days. If the practitioner doesn't do that, any affected person can apply to court for those votes. If this person was present at the meeting, to have these opposing votes set aside as inappropriate. And if that happens, then the majority would have been in favor of the plan, because you have now eliminated the votes of people who rejected the plan. Now, in the Act says that the meeting must then be postponed. But as the Supreme Court of Appeal in KJ Foods pointed out, why should there be another meeting? If the company or if the court agrees to set aside the opposing votes, then you have an approval of the plan. Why have a meeting again? Now the plan has now been approved, and you can go ahead and implement the plan. And if the court does not set aside these votes, then the plan has been rejected, and that's the end of the business rescue. And then you have to just inform the CIPC that the plan has been rejected, and that's the end of the story. The problem comes in with, how do you test whether the vote of a creditor is inappropriate and should be set aside as inappropriate? Now, you'll see in the textbook there is a discussion of the case of Advanced Technologies and Engineering Company, where the Judge Tuchten remarked obiter that you cannot set aside, you cannot tell somebody that his vote is inappropriate. So all you can do is to say that the result of the opposing vote was inappropriate and therefore has to be set aside. However, there are several cases in which the court said you cannot set aside the vote of a creditor who rejected the plan if that creditor was acting reasonably and bona fide in protecting his own interests. And that basically is why creditors get to vote on the plan. That's to protect their interests, because, as you know, in most cases, they are not involved in the commencement of the business rescue. They cannot stop it from happening, but their rights will have to be exercised when they vote. And if the plan is no good, then they can vote against the plan. So the courts could not agree on the test for inappropriateness. Some said a creditor has to protect his own interests, and he must just be reasonable, and then it cannot be inappropriate. Others said, no, you cannot. And KJ Foods specifically said, and this was a Supreme Court of Appeal case, a creditor cannot just vote in his own best interests. In other words, the test is not a subjective one. What is in the interests of this creditor and what is reasonable for this creditor. A creditor, before voting on the plan, must take into consideration the interests of all affected persons, the whole body. For instance, employees who may be losing their jobs if the plan is rejected, or other creditors who may not get a proper and substantial dividend or payment on their claims. So you have to look at what is reasonable in the light of the advantage to all the affected persons. In other words, the test for inappropriateness is objective. If viewed objectively, the vote of the creditor who rejected the plan was only in his own interests, and he did not take into consideration the interests of the other affected persons, then that's inappropriate. Now, because there was a difference of opinion among the courts, it wasn't very clear what the situation was until recently, when the Supreme Court of Appeal handed down its judgment in the Ferrostal case, Ferrostal versus Transnet, and you see the reference there if you want to go and read it. Basically, what it came down to is that the Supreme Court of Appeal has now made it clear that the test for inappropriateness is objective. In other words, when deciding whether the vote of a creditor rejecting a plan was inappropriate, the court will look at the interests of all affected persons. Now, in this case, the court refused to set aside the vote rejecting the plan because there were no employees in this company and there was no real business. Their only business was subletting certain property that they were leasing from Transnet. So the court said there are no employees to consider here whose interests must be considered. There are no other creditors. There's no business really that we should look at to see whether it should be continued. So in this case, we cannot say it was unreasonable of Transnet to reject this plan. But the test is an objective one. And if there are other affected persons involved, we have to look at their interests as well. Right. Then the third possibility is, if none of the above is done, is that an affected person may make an offer to acquire the votes of people who voted against the plan. Creditors can acquire the votes of other creditors. Shareholders can acquire the votes of creditors and other shareholders. But it's you only buy the votes of people who voted against the plan if you want the plan to be approved. So you basically buy enough votes to be able to have enough people voting in favor of the plan. And although it isn't clear from the provisions of the Act, I would say that it's not just the vote you're buying, you are buying probably, I think, the claim on which the vote is based. Because if you don't have the claim, if you don't own the claim or the debt, you cannot vote on it. So it's really acquiring the claim, and that will give you the votes you want, so that you can change them from opposing the plan to agreeing to the plan. Then the question then is, if nothing is done, Section 153 states that if nobody does any of the above, then subsection 5, if no person takes any action contemplated in subsection 1, that's now applying to court or buying votes or drafting a new plan, then if no person takes any of this action, the practitioner must promptly file a notice of the termination of the business rescue proceedings. So the business rescue proceedings will then end. The question was, does it end only when the practitioner files the notice to say that nothing has been done, or does it end the moment it becomes clear that nobody is going to do anything to turn around this rejection? And in that Agri Oil Mills case, the KZN court in Pietermaritzburg said you don't need to file the notice. The notice is for administrative purposes, so that the CIPC will know that the plan was rejected and nothing was done to get the necessary votes to approve it. And so that's the end of the business rescue. You need to inform the CIPC about that. So it is an obligation of the business rescue practitioner to file this notice with the CIPC, but the business rescue actually ends immediately once the plan has been rejected and nobody has taken any of the steps to change that. Okay, so Section 132.2 contains the provisions regarding the termination of business rescue proceedings. How does it end? And you have to end it, because otherwise the business rescue practitioner will remain liable, and the company will be recorded, or will be described on the records of the CIPC as being in business rescue. So in some cases you need a court order, in others it's just a filing of a notice. So you need a court order to set aside the resolution that commenced the business rescue, and that will terminate it. And in fact, if you apply for the practitioner's appointment to be set aside, the court has the power to say, you know what, I'm not going to appoint a new practitioner. This is not a proper business rescue case. And then the court can actually also terminate the business rescue proceedings themselves, although the application was only for the removal of a practitioner. The court can also order termination and place the company into liquidation, where the business rescue practitioner has come to the conclusion that there is no reasonable prospect of a rescue. Now, the Act talks about conversion. There is no provision for a conversion. In all the cases where the Act provides for a company in business rescue to be put into liquidation, it's clear that the business rescue proceedings must be terminated because there is no prospect of a rescue, and then there must be an application for the company to be placed in liquidation. Then, if the business rescue proceedings were commenced by court order, you must go to court to terminate them if you come to the conclusion that the company is no longer in financial distress. And if that happens before there's a plan has been approved or anything like that. Then, to terminate business rescue proceedings with a filing of a notice with the CIP, if the plan is rejected and no further action is taken. Now, Section 132(2) creates the impression that it ends when you file the notice, but when you look at 153, no, let me see. 153 states you must file the notice. So that creates the impression that you must file, that it ends when you file the notice. 132(2), however, simply states that the business rescue proceedings will terminate if the plan is rejected and nothing further is done. So I think we must follow Section 132(2). In other words, if the plan is rejected and nobody takes any further action, that's when the business rescue ends, but the practitioner must file a notice to that effect with the CIPC so that the CIPC can rectify its records and be updated. Then, if there's been a plan that was approved and there's been substantial implementation, then the business rescue practitioner must file a notice of substantial implementation with the CIPC. The Act does not indicate what would be regarded as substantial implementation. The implementation has really got underway. And then also, if the business rescue was commenced by board resolution and the business rescue practitioner comes to the conclusion that the company is not really in financial distress, then the practitioner can file a notice with the CIPC to say that the business rescue proceedings must terminate, and he must actually do so, he or she, if they come to the conclusion that there is no financial distress. So that is how you terminate it. And as I say, it is important to formally terminate it so that the CIPC records are correct. Right, then that is as far as we go with business rescue. Please remember to use your textbook and your the Companies Act and your study guide. The study guide is important because it contains cases and discussions that are not found in the textbook. Right. Now we get to the last part of the workshop, and that is to deal with the compromise between a company and its creditors. And as I said before, remember, this is a separate procedure. It is not the same as business rescue. It is not part of business rescue, although it is found in the same chapter of the Act as business rescue, but in the very last section. Now, under the old Companies Act, or the previous one, it was possible to have a compromise with creditors in terms of Section 311. It worked quite well, but it was an onerous and an expensive procedure because you had to go to court twice to have it approved. In the new Act, you find in Section 155, it only deals with a compromise with creditors. So whereas Section 311 also provided for an arrangement between the company and its shareholders, in the new Act, they have separated the two. So Section 155 only deals with a compromise with creditors. It is another option for companies in trouble, but it is not a requirement that the company must be in financial distress. So it's just if it's having some difficulties, this is one thing that they can use. Now, a compromise basically means it's an agreement with a creditor or creditors for them to either receive something less than is owed to them, or that they are paid over a longer period. That's why it's called a compromise. So the compromise is proposed by the board of the company, or if the company is already in liquidation, the liquidator may propose a compromise of its financial obligations to creditors, or just a class of creditors. The disadvantage of this is that unless the company is in liquidation, where no claims can be enforced, but if it's the board that is proposing this compromise, there is no moratorium during the negotiations to protect this company from claims by creditors. So if you start talking to your creditors, it is possible that some of them may try to enforce their claims or even apply for liquidation of the company because they now realize that there is a problem, a financial problem in the company. The proposal, you will see it's set out the prescribed contents in detail. And what they've done, it's again a legislative shortcut, which should not have happened. What the drafters did, they simply took all the requirements for a business rescue plan and they transferred it to a compromise. Now, in actual fact, a compromise is supposed to be a very straightforward, simple process, and your compromise or your proposal should only contain what is necessary for the creditors to know, to decide whether they want to accept it or reject it. That's all. You don't need all this information. So it's really a pity that the drafters saw fit to just take over everything that's required for a business rescue plan, which even for business rescue is too much. So basically, you should only look at that first paragraph. It must contain all the information reasonably required to assist creditors in deciding whether to accept or reject this proposal. Right. Now, a proposal for a compromise is adopted if it is supported by a majority in number, representing at least 75% in value of the creditors or class of creditors present and voting at the meeting. So here it's again 75, at least 75% in value and a majority in number. The company, it then says the company may apply to court for approval, but if you read the section, you will see that actually the company doesn't really have a choice. It must apply to court for approval of the adopted proposal. The court may sanction the proposal if it's considered just and equitable, having regard to the number of creditors who were present and voting in favour, and the report of the master in the case of a company being wound up. So a copy of the court order sanctioning the compromise must be filed with the CIPC by the company within 5 business days, and it must be attached to each copy of the memorandum of incorporation. And a sanctioned compromise, in other words, if it has been approved by the court, is final and binding on all the relevant creditors as of the date of filing. In other words, it's not only applicable to the people who voted in favor of the proposals, but all the creditors or all the creditors in that group. Now, the reason why a company in liquidation would make such a proposal is if usually an outsider makes money available to the company to say, I will pay the debts or part of the debts on condition that, so I will make the money available on condition that if the proposal, if the compromise is accepted and sanctioned, then the company will be able to apply for the liquidation order to be set aside. In other words, the liquidation will come to an end and the creditors will not oppose this application. That is why a company in liquidation would want to enter into a compromise, because otherwise they can just get the liquidation, let the liquidation carry on. And the other advantage for a company in liquidation is that it is a very inexpensive procedure. It's not like business rescue where somebody has to be appointed and be paid extra fees. The compromise is handled by the liquidator. If the company is not in liquidation, then it is done by the board. So there can be certain advantages to a compromise, and this is something that companies should not forget about. In some cases, it can actually be have a bigger advantage for the company, and it, as I said, it will be much cheaper for the company than a business rescue. And that, ladies and gentlemen, is the end of my story. I hope this workshop will help you a little bit in understanding the work. And remember, if you have questions, send them by email, not later than 16 May, to Mrs. Libber, so that we can see what your questions are and we can try to answer your questions. Thank you very much.